All right, Ms. Smart, you are arrested for aggravated assault with a deadly weapon. And if I remember right, this was, yeah, it's a knife situation. And looking at your, you do not qualify for pretrial release. You do have, it's a 0 felonies, 4 misdemeanors, 0 failures to appear. Last conviction was an assault on a police officer, disorderly intoxication. These are listed, driving under the influence, assaulting a police officer, rowdy disorder. So, when I consider everything, we'll go ahead and put your bail at $10,000. So your bail is $10,000, and you are not to return to the scene of this incident. You are not to contact the alleged victim, witness, or co-defendants. Your attorney will do that. Do not leave the state. Do not possess any weapons, firearms, or ammunition. Do not consume any illegal drugs. No contact, no return. I believe I already said that. State, is there anything else?
No, Your Honor.
Your Honor, if I may, there are no felony convictions on her record. She does have some past misdemeanors. I would just ask if you would reconsider the $10,000 bond, lowering it to something.
No, not based on her history.
Understood. Thank you.
Okay, next should be Robert Gilliam. Gillum?
Yes, sir.
Okay, Mr. Gillum. First off, we have possession. You're out on bail.
ROR.
Well, okay, ROR, but I revoke that. And this is possession of fentanyl and possession of controlled substance. And we'll go ahead and set possession of fentanyl. We'll set that.
Oh, excuse me, Your Honor.
Yes.
I believe the possession of fentanyl is his other case. Today, he's being initially appeared on a trespass case.
Yeah, that's from another case that's like 3-4 months old.
Okay, you're trespass of warning, but he's out on ROR.
From the other case, yes, sir.
Right. So we're talking about case number 22MM.
17.
No, I'm sorry. 2022 CF 005119 AO. And so that is, the ROR is revoked. And
Your Honor?
Yes.
I apologize for interrupting. The new case is 22MM7283, which is the trespass on property after warning. The offer from the state is an adjudication of guilt, credit time served, and no return to the publics, located at 5265 South John Young Parkway. I believe that the defendant is going to accept that offer, and I'm sure that defense is going to argue that in light of him agreeing to resolve the misdemeanor, that you take no action on the felony.
okay,
I do
is that
appreciate
agreed?
the comments from the state, and I absolutely would argue that.
Okay, all right. Then let's swear him in, please.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, have you read your plea form and do you understand it?
Yes, sir.
And if you are not a United States citizen, then your plea may cause you to be deported. Madam Clerk, what's the court cost? And this is a misdemeanor. Okay, 323. Okay. All right, your court costs are 323. I accept a no contest plea, adjudication, time served, which is how much for the record?
2 days.
2 days. Public defender services is $50. And do you agree that that's a reasonable fee? All right, and you are given 30 days to go to the courthouse, one of the courthouses, and to either pay in full the amount due or enter into a payment plan. They're really good, easy. You can do $20 a month. And so if you fail to enter into a payment plan or to pay the money within 30 days, your driver's license and motor vehicle registration, if any, will be suspended until the money is paid. All right, and do you understand everything, sir?
Sir.
All right, thank you very much.
And so, Your Honor, with regard to the out on bond, is it no action?
Right, no action on the out on bond. The ROR, I mean. Okay. Next should be Mitchell.
Your Honor, case number 22MM7278, trespass on property after warning. The offer from the state is an adjudication of guilt, credit time served, and no return to Universal, located at 8523 Commodity Circle.
All right. Okay, Madam Clerk, if you would swear her in.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
All right, and did you read and understand your plea form? You have to say yes or no.
Yes, sir.
Okay, very good, thank you. If you're not a United States citizen, then your plea may subject you to deportation. Court costs, Madam Clerk? $323. There's no cost of investigation. I accept a no contest plea. I do adjudicate. Time served is
2 days.
2 days and sentence to 2 days. Public defender services are worth $50. And do you agree to pay that amount?
I agree to pay the amount of
Okay.
$50.
All right, very good. And what did you say the court cost was? $323. And I want you to go to one of the courthouses and either pay the money that I've just ordered you to pay or enter into a payment plan. It can be as little as $10 a month. But you, as a responsible person, need to meet your obligation, which is to pay the money that you owe the taxpayers. So you must, within 30 days, go to one of the courthouses, as I've said, and either pay or enter into a payment plan. If you do not, then any license or identification or vehicle registration will all be suspended until you pay that money. Do you understand?
I do understand fully.
All right, thank you very much. Next,
Have
next,
a great day.
next defendant, please.
What happened to Mr. Molina?
Yeah, this is Carlos Molina? Oh, he is? Okay. All right, we'll reset Molina. All right. Let's just reset when he's returned.
Your Honor, at this time, Your Honor,
Yes.
If I may, at this time, the Public Defender's Office will waive the appearance of Mr. Molina at his initial appearance.
Yes. Yeah, it's a waiver. And let me see the. All right, let me see what the paperwork is. All right, this is a trespass on property after warning and then resisting an officer. We are talking about Carlos Molina.
Yes, Your Honor.
Okay, wanted to make sure.
If you've already appointed the Public Defender's Office to his representation, we would waive his appearance at this time.
Yes. And so let me see. Is 5 felonies, 22 misdemeanors, and then they just go on for like a page and a half. And so the trespass on property after warning will change that to be $1,500, and resisting the officer would change that to be $500. And then he is to no return, no contact, no weapons or ammunition. Just a second. Okay. Sammy Pursley?
Yes, sir.
Okay, Mr. Pursley, you are arrested for a misdemeanor battery, and do we have a plea?
No, Your Honor, there is no offer.
Okay, all right, and Mr. Pursley, you have 21 felonies, 21, at least you're consistent, 21 misdemeanors, no failures to appear, and then and so the battery will change that because of your extensive history to be $1,000. And so no contact, no return, no weapons or ammunition. Anything else, State?
No, Your Honor.
Thank you, Your Honor.
Okay, next is Pamela, is it Rash?
Yes.
Okay, Ms. Rash, you are arrested for trespassing. It's a misdemeanor, trespassing, and she has no history that it shows here. So is there a plea here?
The offer from the state is a withhold of adjudication and credit time served, no return to 12766 Robin Cherney Way. If Ms. Rash is not inclined to accept that offer, state has no objection to ROR.
Your Honor, at this time, we will not be accepting the offer, and we will ask for an ROR.
Okay, by agreement of the parties, we'll do ROR. And ma'am, no return, no contact, no firearms or ammunition. Anything else, State?
Your Honor, may we have a second? I apologize. Yeah, but you have to have it. All right, you may continue.
Okay, what are we doing?
Well, they told me I had 3 options: to have an attorney, to defend myself, or a public defender. And I declined. I said I wanted to defend myself because I'm here. Yes, I did trust you, but I'm here on the basis of mercy for my son. My son is developmentally delayed, and I haven't been a part of his life due to a 36-year marriage that I'm in the midst of a divorce. And,
Well, you're going into a lot of things that are not relevant. So so your options today are to either plea and have this behind you and be done with it, or for me to release you on your own signature and for you to show up at a later date in another court and to argue your case when the case is ready. So what do you want to do? Those are your
here today,
so you can dispose of it today, or you can go to court and have a trial where the state has an opportunity. Because see, by you telling me just your side of it, it denies the state due process. The state has an opportunity to have witnesses, to interview people, and to be ready. So by you trying to try the case in front of me today with the state unprepared for a trial, then that denies the state due process. I wouldn't do that any more than I would deny you due process. I wouldn't let the state try you. But if everybody agrees to a plea, then no harm, no foul. So what do you want to do?
oh, okay, I understand. I didn't know that. This is all new to me, so I didn't know that I wasn't supposed to explain to you. But I guess I need to explain my whole situation, so I guess I have to go.
Well, the only situation I care about is whether or not you want to go to trial or not.
Trial.
You want to go, okay, so we'll go ahead and release you on your own recognizance. And was the person involved, was that your son? Was like an adult son?
Yes.
Okay,
It was,
all right, so we'll do no hostile contact. Okay, all right, and so ma'am, make sure we have your right address so we can notify you when the hearing will be. Thank you very much. Okay.
sir, I don't have an address. The address that I was trespassed on was my address that I was using for my mail.
Okay, all right,
I'm out of state.
okay. All right, next we have Kirk Morton, or Throckmorton.
#22 MM 7286. The offense is trespass on property after a warning. The offer from the state is an adjudication of guilt, 30 days in Orange County Jail, credit for any time that has been served, and no return to the DoubleTree located at 10100 International Drive.
Okay, and so we'll take no action on the ROR.
Well, I don't know if the offer is
Your Honor,
accepted
at this
or
time,
not.
I would appreciate, we had some confusion about the offer when we initially heard it. I would appreciate if we could recall this case and give me an opportunity to speak further with my client.
Oh, I have no objection.
Oh, okay. All right, I'll just put it at the end. Okay.
Would the clerk be able to tell me how many days he has served, Mr. Throckmorton? Pretrial release?
2 days.
2 days? Thank you.
Okay. Next we have McLean.
Mr. McLean has 2 cases, 21 MM 257AE and also 21 MM 7403. With regard to 21 MM 257, that is a petty theft with a prior conviction. The offer with regard to that case is an adjudication of guilt, 15 days in Orange County Jail, followed by 12 months of supervised probation. He is to do the impulse control class. There is a cost of investigation of $62.27 to the Winter Park Police Department, and he is not to return to Nordstrom Rack located at 1090 North Orlando Avenue. In addition, 21 MM 7403, that is also a petty theft Offer from the state is an adjudication of guilt, credit time served, and no return to the Walmart located at 8101 South John Young Parkway.
Your Honor, at this time, we'll be accepting the plea
All
Both
right.
cases?
in both cases, yes.
Thank you.
Okay, and then, so on, so we'll do the 257. Sir, we need to swear you in first.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, and so on the 257, did you hear what the state had to say? Madam Clerk, State Attorney, I was doing something, so I apologize. On the 257, what is the plea?
Certainly.
proposal?
Again, it is an adjudication of guilt. He will serve 15 days in Orange County Jail, followed by 12 months of supervised probation. He is to do the impulse control class. There is a cost of investigation of $62.27 to Winter Park Police Department and not returned to Nordstrom Rack, located at 1090 North Orlando Avenue.
Okay. All right, sir, did you understand that?
Yes, sir.
All right, and so we'll go ahead and adjudicate the sentence you to 15 days plus credit for time served of 2 days, plus, so 15 days plus 12 months of probation. And so, so county probation, and then the cost of investigation is $22.57. And then no return, no contact with the victims of this, in this case.
Winter Park
No, Winter Park Police. Yeah, and so, so that, so sir, in addition to that, it's $50, public defender service is $50. And do you agree? Yes or no? All right, and the court cost, Madam Clerk, for 257 is? Yes. Just take a second. So he's going to serve a sentence of 15 days and then a year of probation.
He has 41 days already on this case.
Oh, well, credit time served then.
So 345.57? Okay, you got that.
Your
Okay,
Honor,
yes.
Just to bring to your attention, I've just been notified that on 257, the defendant has actually served 41, 47? He's served over 15 days in Orange County Jail, Your Honor, therefore it would just be a credit time served offer.
Oh, okay. So we sentenced him to 15 days with credit for time served of 15. So,
41.
41.
41 days, yes. So if he served 41, should we just sentence him to 41?
Yes, Your Honor, just give him a credit time served.
Yeah, so, okay, 41 sentenced and 41 served. Let me ask you, do you have to combine probation with time served? And this being a misdemeanor, could only be a year, so,
Yes, Your Honor, therefore you can reduce it to 10 months.
yeah, let's do 10 months. So the 10 months of probation,
No objection from the defense.
okay, and then Madam Clerk, are we good with, are we done with 257?
This needs to be fixed, Your Honor.
you have him initial this, please? The changes on the plea form. Just at the top. Okay, while he does that, so that we'll conclude then the 257. And so next we're going to do, here, let me see that again. Okay, then next we're going to do the 7403. 7403, okay. All right, now, so on 7403, we'll go ahead and accept a no contest plea adjudication. The time served will be 41 and 41, 41 sentence, 41 served.
Your Honor, as it's a different case number, the credit time served is not the same.
Oh, it isn't?
2
Okay,
days.
okay, so, okay, what is the time served then on 7403?
2 days.
2 days? All right, so we'll do the 2 days there. And then, Madam Clerk, since it's time served with no probation, what would be the clerk's fee then? Any other
No, Your Honor.
323? And then we'll just do the one public defender fee. And then, sir, you're ordered to go to one of the courthouses and either pay the money or enter into a payment plan within 30 days. If you fail to do that, then your driver's license and vehicle registrations, if any, will be suspended until you pay the money. Okay, State, did we do everything?
I believe so, Your Honor.
Okay, all right, thank you very much. Next case, please. Oh, the clerk has a question.
27,
Yeah, 22,
6227,
67?
6227.
Yeah, I had it wrong. I wrote it down because it's for some reason it's hard to hear a little bit. So is it
6227.
Okay, 6227, 6227. Thank you. It's funny, as small as this room is it often is hard to tell. Okay, next should be Christopher Blake. Okay, Mr. Blake, this is Blake. This is an ordinance violation, alcoholic beverage, open container. State.
Yes, Your Honor. The offer from the state is an adjudication of guilt and credit time served.
All right.
Case number is 22MO1203.
Correct.
I believe the defense forgot to write that offer down, so if you don't mind recalling this one, so I have a chance to re-speak with my client on this one. You just want to take it? He just wants to take it. But we need to go over the form and stuff, my man. I apologize to the court.
You said adjudication.
Yes.
Yes. Adjudication and time served and money.
Your Honor, this time we're ready to proceed.
Okay.
It's over right now.
Madam State, you said the offer was an adjudication of guilt with credit time served?
Yes. And just for the defense, as it is a city or county case for the next three, it's either going to be a withhold or a
What's the rest of it?
adjudication.
No, it's just this one.
What is it? What is that camera up there? Oh, oh, is that what that is? Okay. All right, let's swear the gentleman in.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, did you read and understand your plea form?
Yes, I did.
All right, and if you're not an American citizen, then your plea may cause you to be deported. And the court costs, Madam Clerk? $273. Time served is how many days?
1 day.
1 day. And sir, the services of the public defender service is $50. Do you agree? Okay, and you can put your hand down. And the court costs we've already done. And so I want you to go to one of the courthouses and either pay in full the amount that you owe or enter into a payment plan. This can be done, you can pay by credit card or cash. If you, or enter into the payment plan, it must be done within 30 days from today, the day of your release. And if you don't do that, then your driver's license and vehicle registration, if any, will be suspended until you pay. Do you understand?
Yes, Your Honor.
All right, thank you. Next defendant. Next, we have Ted Johnson.
Yes, sir.
Okay. Mr. Johnson, you were arrested for an ordinance violation of disorderly conduct.
The offer from the state is a withhold of adjudication and credit time served. I apologize, I couldn't find the case number.
Okay, it's 22MO1204 Apple, Orlando.
Yeah, it's,
And so adjudication and time served?
No, Your Honor, it's actually a withhold and credit time served.
Oh, okay. So withhold and time served. Okay, and then there'll be money
Would
involved.
you mind reading that case number again? It appears I had the wrong one as well.
Okay, Madam Clerk, would you, this is sort of,
22MO1204AO.
everybody got it?
Thank you.
Your Honor.
Okay,
This time, Your Honor, we do have a plea form signed. I can walk it up. I can walk it up.
thank you. Okay, just put him under oath, please. Under oath. No, you don't need to stand unless you're.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
Put your hand down.
And so, sir, did you read and understand your plea form?
Yes, sir.
And if you're not a United States citizen, then your plea may subject you to deportation. And so there's a withhold of adjudication. And your time served, pretrial release,
2 days.
2 days, sentence to 2 days, time served, 2 days. Madam Clerk, the court cost? 273. And then $50. The Public Defender Services is $50. And do you agree?
I guess, sir. I
Okay.
have no money, so.
Okay, we'll talk about that in a minute. After you're released, you are to go to one of the courthouses and enter into, and either pay them in full, the money you have, the money you owe, or enter into a credit payment arrangement. That must be done within 30 days. If you fail to do that, then your driver's license and vehicle registration, if any, will be suspended until you pay. Do you understand?
Yes, sir.
All right. Thank you very much. Next defendant. Next is Jermaine Smith.
Case number 22MO1205. The offer from the state is an adjudication of guilt and credit time served.
All right.
At this time, we will be accepting the offer, Your Honor. Could I ask the clerk to read the case number in this one as well?
22MO1205AO.
Thank you.
You're welcome.
Your Honor, I appreciate the court's patience. We are ready to proceed.
Well, you know, the work you do is really valuable, and I appreciate your work and the public defender in general and your work particular. Everything is relaxed and we're just doing our jobs. So thank you for your work.
Sir.
No.
2 days.
Okay, did you, okay, you're right. Okay. All right, now we are talking to Mr. Smith, Jamal Smith. And Mr. Smith, this is ordinance violation, open container. And what was the agreement?
Adjudication of guilt and credit time served.
Okay, and so swear him in, please.
Please raise your hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth so help you God?
All right, and did you read and understand your plea form?
Yes, sir.
All right, and if you're not a United States citizen, then your plea may cause you to be deported. Do you understand that?
Yes, sir.
We have adjudication. We accept a no contest plea adjudication. Time served. Pretrial release.
2 days.
2 days. Sir, the public defender services is $50. And do you agree?
Yes, sir.
And court costs, Madam Clerk?
It's gonna be $273.
$273. And sir, you are ordered to go to one of the courthouses in Orange County and to pay in full the amount that I've ordered you to pay. This can be done by cash or money order, or at the clerk's office, you can enter into a payment plan. If you must do this within 30 days from the date of your release, or your driver's license and vehicle registration, if any, will be suspended until you pay. Do you understand?
Yes, sir.
All right, state anything else?
No, Your Honor.
All right, next case, next defendant. Okay, Gregory Spruill? Okay, and this is an ordinance violation, alcohol, open container.
22MO1206. The offer from the state is an adjudication of guilt and credit time served.
Your Honor, at this time, we'll be accepting the plea.
Okay. All right, swear him in, please.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
Oh, thank you. You know, I just was just wondering, State, you know, he's not testifying in the sense of testimony. Do you think we always have to swear them in to take a plea?
I believe so, Your Honor, only because they do respond to your questions, and therefore they should be sworn in.
Okay. Agreed. He's busy. All right, sir. Did you read and understand your plea form?
I did.
And if you're not a United States citizen, then your plea may cause you to be deported. Do you understand?
Yes.
And I do accept a no contest plea. I do adjudicate. Time served is 2 days. And correct me if I'll just be using 2 days unless you correct me. Public defender services is $50. Do you agree?
Yes.
And your court cost, $273?
Yes, Your Honor.
And, sir, after you are released, you are to go to the, one of the courthouses and to pay in full the amount I've ordered you to pay. This can be done in cash or credit card, or at the clerk's office, you can enter into a payment plan. You must do this within 30 days from the day of release, or your driver's license and vehicle registrations, if any, will be suspended until you pay. Do you understand?
Yes, I do.
All right, thank you. State anything else?
No, Your Honor.
All right, the next defendant. Now, you put the paragraph in there that, what I'm saying. Or a D6, or however way you do it. Okay. Can you find Dominique? Okay, David Mamich. And this is a failure to appear. It's $1,000 bail, and we'll leave that as is.
Your Honor, 20 CT 3602, the underlying offense is driving with a suspended license with knowledge. The offer from the state is a withhold of adjudication and credit time served.
And Your Honor, at this time, we will be accepting the plea.
Okay, sir, have you reviewed and signed your plea form?
Yes, Your Honor.
Okay, swear him in, please.
Please raise your right hand. Do you solemnly swear to tell the truth, the
thank
whole
you.
truth, and nothing but the truth, so help you God?
I do.
You can put your hand down.
Okay, and if you're not a United States citizen, then your plea may cause you to be deported. Do you understand that?
Yes, Your Honor.
And I accept a no contest plea and a withhold of adjudication. The public defender service is $50. Do you agree?
Yes, Your Honor.
And court cost is $273, Madam Clerk? No.
Be 301.
301? Okay, 301. After you are released, you are to go to the any courthouse, any Orange County courthouse, and to pay the money I've just ordered you to pay. It can be done in cash or a credit card, or at the clerk's office, you can enter into a payment plan. You must do this within 30 days from the date of your release, or your driver's license and vehicle registration, if any, will be suspended until you pay. Do you understand?
Yes, Your Honor.
All right, state anything else?
No, Your Honor.
All right, next defendant. Next defendant should be Turner.
Devontae Turner, 20 CT 1067. It's a failure to appear, but the underlying offense is a no valid driver's license. The offer from the state is an adjudication of guilt and credit time served. With regard to 19 MM 9787, it is also a failure to appear. The underlying offense is stalking and criminal mischief. Defense has the offer for that. It's long.
The offer is 12 months supervised probation and batterers intervention program, no contact with the victim, no return to the victim's home, $109.59 a cost of investigation, $420 in restitution and court costs. And at this time, Your Honor, we will be accepting the plea.
All right, swear him in, please.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, thank you. All right, on this failure to appear, adjudication, oh, swear. Okay, this is the one that ends in 9787. I'm sorry.
Oh, is it?
This is, it says stalking,
Oh, the 19? Eee. I do apologize. That is my error. I did not see that.
okay,
I do apologize.
well, let's just, yeah, we can back up. We haven't done anything. So, so we need to have a new understanding, so should we
Defense would
just
request to withdraw
um,
this time.
set bail today and deal with all this as a package later?
Your Honor, again, as it's a failure to appear, the bond stays as set by the judge in the division.
All right, we do have, okay, so we do have the failure to appear. It's a no bond situation from that, for that judge. And then we have another failure to appear. So both, so everything in front of me is no bond.
Yes, Your Honor.
Okay, and that's Mr. Turner.
Yes, sir.
Why did I look?
Okay, I have, this one I didn't have and I noticed.
Your Honor, with regard to the violation of probation, 19 MM 9787, there is an offer. It is 60 days in Orange County Jail, but it would revoke and terminate his probation.
Well, we're having a little paperwork problem here. I don't know which one you're talking about.
We're still talking about Mr. Turner, are we not?
Okay, well, here's Turner and Turner. I'm sorry. Go ahead. Would you?
Yes, Your
I've
Honor.
got in front of me the two Turner matters.
Yes, Your Honor. The state made an error in making an offer on the violation of probation. It was the wrong offer that was relayed to the state, relayed to defense, that was then relayed to the defendant. I believe he understands the mistake that has been made and therefore withdrew his plea. I am now making an amended offer based on the correct information that this is a violation of probation. So with regard to 2019 MM 9787, the offer from the state is to revoke and terminate the probation for the defendant to serve 60 days in Orange County Jail and to receive credit for any time that he may have served.
Okay, so we'll deal one at a time. So we have the,
Your Honor, I don't know if the defendant is accepting the offer. I'm just
Oh,
clarifying the record.
I
yes,
appreciate that. Your Honor, this time I think it'd be best if we could recall this case to give me an opportunity.
No. I don't
At this time, we'd like to recall this case, put it at the end of the docket, and recall it again today.
I can't quite understand you.
Your Honor, at this time, we would appreciate an opportunity to speak further about the offer that's just been extended. If we could recall this case at the end of the docket today, that would be wonderful.
Okay. Turner.
What is the person's name? You have the booking number or the name?
The booking number is 220-253-23.
That person has bonded.
I'm sorry,
Bonded.
you bonded?
Yes.
Okay. So this,
All right, now I have next Era, let's see, Era Gomez. Okay, this is Jack Arrow Melendez, I guess. Let's see, Araliga Melendez, or is that your name? Okay, I'm sure we've run them together, right? Okay, so your last name is Melendez? Okay, very good. All right, Mr. Melendez, you have been arrested for a felony, failure to appear, and then also there's a second case here of a burglary of a structure and grand theft, third degree, of a motor vehicle. And so, the failure to appear, that judge issued a warrant, and it's a no bond situation, so we'll leave it as is. We'll take no action. Then on the new charge, which is the one that ends in 3258, this is a burglary of a structure and grand theft of a motor vehicle. And let me just look at something. And, all right, and these are capiouses, so he is entitled to a bond, and correct me if I'm mistaken, even though it's a warrant. Well, the warrant has 0.
Some offenses do come in at 0, Your Honor, but the IA judge can set a bond. So with regard to 21 CF 13258BO, yes, you can set bond on those 2 offenses.
Okay, all right. We'll go ahead and let me look at, apparently, see defendant, let's see, burglary of a structure. Okay, all right, we'll go ahead and burglary of a structure, we'll go ahead and put that at $2,500, and grand theft of a motor vehicle, we'll put that at $1,000. No contact, no return, no ammunition, no firearms or ammunition, no contact, no return.
Next.
What is that bond? What was the bond?
For count 1, 2,500, and count 2, 1,000.
Say again, I can't understand you.
Count 1 I have is 2,500, and count 2, 1,000.
Yeah, 2,500 and 1,000, yeah. Okay. I think we've done that one. Okay, now, Trevor Atkinson. Okay, Mr. Atkinson, you're arrested for a felony aggravated assault with a firearm. And let me see if there's more than one. No, it's just that one charge. And all right, now, even though this is a warrant, it says no bond, but does that need to go to the judge, or can I go ahead and set bond?
No, Your Honor, you can set bond.
Okay. So,
Your Honor, I would just note that his risk assessment is low.
again,
Despite the charges, his risk assessment is low. In terms of deciding his bond, his risk assessment is low.
oh, yeah, so the firearm, right, they picked up, State, did you have in front of you the affidavit as to what was this all about?
I do not, Your Honor, but if you give me a moment, I can find it.
Yeah, would you, because my paperwork has just his arrest, but not the fact statement.
Your Honor, the clerks can give you a copy of that if you want to read it for
Can you print
yourself.
that, the affidavit? No, I don't want the warrant to, well, this is a traffic stop, but the underlying,
It appears to be a dispute between neighbors, Your Honor. The incident happened October 16th. And as I said, it does appear to be an argument between neighbors.
okay, I've read the affidavit. I'll put it with the package that I have, because it really should be with it. And we'll go ahead and, because it's a firearm, your bail is $20,000. And you are not to contact the victim. You can return to your house, but you cannot contact the victim in any way. And you are, did you turn the gun that was the subject of this, have you turned that over to the police already?
No gun.
Say again?
Didn't have a gun.
Okay, well,
Your Honor, my client disputes the factual basis in the police report stating he
Okay.
never had a firearm.
all right. You are ordered to, if you have any weapons in the house, any guns, shotguns, long guns, anything, you are to turn those over to law enforcement. You'll get them back at the end. We just don't want any more issues to happen. And so you are prohibited from possessing during the during the bail period, any weapon or any firearm. You're not to contact the victim and state anything else.
No, Your Honor.
Okay.
Your Honor, just to clarify, you said to surrender any firearms or weapons
Ammunition.
within 24 hours?
Yes, within 24 hours of being released. So if you make bail and go home, give all those, any ammunition or weapons to law enforcement during the pendency of this case. All right, thank you. Next case. Let's see, Glenn Batzer, B-A-T-Z-E-R. Okay, Mr. Batzer, you were arrested for a felony, sale and delivery of fentanyl, and then the unlawful use of two-way communication device, plus you have a second case, which is unlawful use of a two-way communication device, and those seem to be the two that I have. And so looking at who you are, it looks like 6 felonies, 1 misdemeanor, 1 failure to appear. Last conviction was this year, possession of a controlled substance. So we'll go ahead and, looking at case that ends in 2602, unlawful use of a two-way communication. We'll leave that as is at $2,500. And then sale and delivery of fentanyl, it's $250,000, which is what comes off the schedule, I presume. And then unlawful use of a two-way communication device in the case that ends in 12603. We'll leave it at the $2,500, and we'll leave the bail as set. With him, the additional conditions are no weapons or ammunition, and no contact in any victims, and no return to the scene of the incident. Next, we have Heather Benjamin. Ms. Benjamin, you are arrested for a felony of child abuse. You do have 3 past felonies, 2 misdemeanors, 1 failure to appear in court. And so and it says the warrant says to be set at IAs. So suggestion for a bail.
Your Honor, I have no objection to a $2,500 bond.
All right, we'll go ahead. $2,500 sounds reasonable for the situation.
We would just note that she did score 0 on her risk assessment. And ask for a reduced bond.
But I don't understand, it says 3 felonies, last conviction was
My client has
08.
informed me that she has only had 1 felony on her record and is confused as to why there's 3 felonies.
Is it a Florida conviction, delivery of meth?
Would also point out the date of those convictions is well over 14, 15 years ago.
Now, has the Department of Children and Families taken custody of the child?
I'm looking at the affidavit.
The child, she's living with her dad, you know?
I didn't quite understand her.
My client indicated that the Department of Children and Families has intervened, and she's currently living with her father, the child.
State, do you have anything to say?
No, Your Honor, I've already made
Okay.
my recommendation with regard
All
to
right,
the bond amount.
The $2,500 is reasonable, plus you must comply with any requirements of DCF as far as the child goes. And you are not to take any illegal drugs. I do order that she be randomly drug tested monthly, and through the pretrial release program. So if you turn up positive, then you'll be back in jail. And no firearms or ammunition. Anything else? Thank you. Next is Jayton Carter. This is Mr. Carter. You were arrested for a felony possession of meth, and there's one charge. And so you don't, let's see, your risk assessment is moderate, and you don't have any felonies, but out of state, there's a whole bunch of things out of state. And so we'll go ahead and change that to be $5,000 with no weapons, no ammunition, no firearms type thing, and no return to the scene of the crime. Anything else, State?
I apologize, Your Honor. Did you stay the bond at 2,000 or did you?
Change it to 5.
5. Okay, I apologize. Thank you.
Oh, no, it's, I'm sure it's just as difficult sometimes to hear down there as it is up here. So, all right, next is Cuevas, Cuevas. Order.
Your Honor, Mr. Cuevas has 3 separate cases. If you could give case numbers.
Okay, okay. Okay, speaking of the first one, it is case number 2022 CF 12583 Apple, Orlando. And this is a battery on a law enforcement or a firefighter. And so the risk assessment is low and really doesn't have much of a history, but does not qualify for pretrial release. So the battery on a law enforcement officer will leave that at the $2,500 on no firearms or ammunition and no contact with the victim. And then we have in case number 2022 CF 012592 Apple, Orlando, the resisting an officer with violence, and it's $100, so we'll leave it as is because it grew out of that same incident. And then we have the one that ends in, that is 2022 MM 000462 AA, and it's $100. We'll leave it as is. And no firearms or ammunition, and no contact the victim.
Your Honor, we would just ask the court to note that Ms. Cuevas is currently a UPS package handler and would ask that you reduce the bond on the initial charge to allow her to be able to bond out.
Would you say that again at the beginning, the first part?
My client is indigent, will be hiring the services of the Public Defender's Office, and we just ask that you reduce the initial bond from $2,500 to maybe $1,000, something lower than, so she can bond out.
I read the arrest affidavit, and I think there's something wrong here with her. When you consider the circumstances, it's so odd. It's almost road rage, and so we'll leave it as is. And so, all right, next we have
Thank you, Your Honor.
I see. D. Thomas. So, sir, this is a felony, petty theft, with 2 prior felonies, and so he has 10 felonies, 4 misdemeanors, 1 failure to appear, and that's just in Florida. Then there are out-of-state convictions of the same thing, shoplifting, merchandise, etc. So we'll go ahead and change this to be $5,000, and no weapons, no ammunition, no return to the scene of the incident, no contact, $5,000. Next is Dotson. Let's see, Dotson, Ms. Dotson, you have a failure to appear, and it's a no bond set by the judge, and so you'll have to see that judge to change that. Thank you very much. Next is Douglas. Now, Douglas, Mr. Douglas, you're out on surety bond, and I will revoke the bond. So possession of a firearm, ammunition by a convicted felon, that bail is $20,000. Possession of a weapon by a convicted felon, we'll go ahead and do that at $5,000, and then carrying a concealed firearm, we'll do that at $10,000. Possession of some kind of drug, we'll do that at $2,500. Possession of cannabis,
I apologize, Your Honor.
$1,000.
Are we talking about Roderick Douglas?
Yes.
Okay, I have 2 new offenses, and then he is out on bond for 1. You seem to be reading a lot more charges than I see before me.
Mine
He was
is,
reading the out on bond. He mentioned revoking it, and he's given the bond amounts for the out on bond charges.
There's 3 charges, there's 3 counts?
I have 4, 5. I have 5 charges.
Okay.
Are we all good? Okay, all right. And so, do you want the clerk to repeat the bonds?
For the, if you're
Yeah.
revoking the out on bonds, Your Honor, yes, please.
Yeah. Oh, did you get that?
Yes, I did, Your Honor.
Go ahead.
Count 1 was 20,000, count 2 was 5,000, count 3 was 10,000, and count 4 was 2,500.
But you said there were 5 counts?
Yes, he was getting ready to go to the 5th one.
Thank you.
Okay, we all good?
Yes, Your Honor, thank you.
Okay. All right, and then no firearms or ammunition, no return to the scene of the incident, and no illegal drugs. And so that's
You forgot.
revoking, you know,
You didn't address the 5th one.
count 5 was.
You never addressed it.
Oh, I didn't? Oh, okay, I'm sorry. This is the cannabis, so that's $1,000. No, that's just out on bond. So that was the case that ends in 580. We good?
No?
No, we're
The
all
out-on
confused,
bond?
Your Honor.
Oh, no, that's the wrong case. I just looked at the wrong case. That's the 2421.
Okay.
Yes.
All right, now are we okay? Okay, and then we have a case that is 2022 CF 012580, and this is possession of a firearm by convicted felon, and that'll be $20,000. $20,000, no firearms or ammunition, no contact, no return. Now, now I have Douglas, Roderick Douglas, and this is the 2022 CF 012581 Apple, Orlando, and this is moving traffic violation, and it has a $2,500 bail, and we'll leave it as is.
Thank you, Your Honor.
Okay, next we have Jeffrey Heatherton. And it looks like we have three cases. Okay, I have 3 cases, everybody. Okay, the first one is a felony, possession of cocaine, possession of drug paraphernalia, and it's the one that ends in 683. No, I'm sorry, that's the wrong number. It's the one that ends in
One case, Your Honor.
2570.
Excuse me, Your Honor. I only have one case for this defendant.
Really? Jones. Oh, I'm sorry. They just got stapled together. Not stapled, but the paper clips had them all together. So let me separate them. Okay. And this is Hetherington, and like we just said, there's only one case. Possession of cocaine, the bail is set at 1,000. Possession of paraphernalia at 100, and we'll leave that as is. Plus condition would be no firearms and no ammunition, no return, no contact.
Thank you, Your Honor.
Okay, now we have Jones, and Jones appears has 2 cases.
Jones Earl's behavior.
Oh, okay. All right, we'll appoint the public defender.
We'll waive his appearance.
And the burglary of a conveyance, which is the case that ends in 2569, burglary of a conveyance. Looking at Jones. He has 9 felonies, 15 misdemeanors, 2 failures to appear. So on the burglary of a conveyance, we'll make that 10,000 criminal mischief. So that's 10,000 criminal mischief. We'll do $1,000. And then the other case that ends in 7281, loitering or prowling is a misdemeanor. So we'll go ahead and do that at $1,000. Next, we have Lampkin, Eddie Lampkin. We'll appoint the public defender.
We'll waive his appearance, Your Honor.
Okay, and this is, let me just, there's only one case, in possession of cocaine. Now, he has 23 felonies, 13 misdemeanors, 3 failures to appear, and everything from grand theft of automobiles, robbery with a firearm. So the possession of cocaine will be $10,000. Possession of drug paraphernalia, we'll do it at $1,000, and possession of meth, we'll do that $2,500. And no firearms or ammunition, and no contact with any victim or return to any scene. Next, we have okay, next we have McCrimmon. McCrimmon, he's out on pretrial release.
Excuse me, Your Honor, I also have a revocation form for him.
And so, okay, right, they've revoked the pretrial release. So, community corrections, notice of revocation of pretrial release. So I don't have to do it then. So, but then he's entitled to a bond, driving while license suspended, revoked without knowledge. So you're Mr. McCrimmon.
Yes, sir.
Okay, and so you're, okay, so you're in jail now for possession of cocaine.
Yes, sir.
All right. So it looks like you have 15 felonies, 17 misdemeanors, 1 failure to appear. And,
I never had a failure to appear.
well, they have one listed for you.
All right, all right.
I mean, but this coke, so, okay, so looking at the driving while license suspended, which is, he's a PTR, so we'll change that to $2,500. And then,
Excuse me, sir. It's a misdemeanor now. They had dropped,
let's see, driving while license suspended or revoked without it says with knowledge, second conviction. This is,
432.
yeah, 432,
AA.
yeah, 2022 CT 000432AA. And they have a bond amount of $2,500. So we'll leave that as is. And then we have possession of cocaine, and $1,000.
Your Honor,
Yes,
could I ask the state to confirm the status of this being a felony possession of cocaine charge that
No, I'm from that.
The driving. The driving offense has been filed on, and he is set for sentencing November 14th. Defendant is correct, it was filed as a misdemeanor, but it also, because of the two prior convictions, if he agrees to an offer, it would be 10 days in jail per statute.
would this be for both cases?
No, 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 Your Honor, I'm not resolving the case, I'm just letting him know that it is a misdemeanor. He was complaining about the bond amount for a misdemeanor. Yes, it is a misdemeanor, but I'm also just informing him that because of what he was charged with, there is a 10 days in jail minimum mandatory
Oh.
for the statute.
Oh, okay. All right, so we'll leave it as is. I've said the one he was PTR, so that's 2,500, and then the possession of cocaine is 1,000, so we'll leave it as is.
Your Honor, would you consider lowering the bond on the driving while license suspended from $2,500 maybe to $1,000?
He has no objection.
No.
Oh.
Next we have Brian Michael. All right, Mr. Michael, you're arrested and you have several charges. So possession, and looking at who you are, your risk assessment, which I do think about, because I do believe in risk assessment, an analytical approach to setting bail. I think there's merit to it. And he does qualify for pretrial release, but we must not be talking about the same person. Brian Michael
Yes, Your Honor.
qualifies for, it can't be, because he has carrying a concealed firearm. Now, there must be a mistake there somewhere.
No, he qualifies.
Your Honor, because he qualifies does not mean that you have to give him pretrial
Oh,
release.
no, I know that. I'm just surprised that he would even qualify when there's a gun involved. I guess. Anyway, so the possession of cannabis including a weapon is set at the 15,000.
Your Honor, if I may,
Yeah,
he does qualify for pretrial release. I understand the hesitation that you have. He has no convictions on his record. I would absolutely ask that we allow him to be released pretrial without bond.
okay. I guess the possession of cannabis with a weapon, we'll leave that as is. Carrying a concealed weapon is $20,000. Concealed firearm, I meant, is $20,000. Possession of cannabis would be $1,000. Unlawful possession of stolen credit cards would be $5,000. Unlawful impersonating known and unlawful possession, I can't even read that, we'll leave it at the 500. And so once a person begins carrying a firearm, that's a different ballgame entirely. And so he's got 15,000 on count one and 20,000 on count two, and then the others remain the same. And then if he makes bail, he's to have no firearms or ammunition, and he is to be drug tested by pretrial release monthly. And if you're positive for drugs, you will then will be a violation of your bail, and you're going to be back in jail. And so, so no drugs, no firearms or ammunition. Anything else, State?
Your Honor, I just need to clarify with regard to count 4, which on my paperwork is the unlawful possession of a stolen credit card. When it came in, it's listed on my paperwork as $1,000. I believe you raised it to $5,000.
Yes.
Then you said everything else remains as is.
Well, right, I raised it to 5. I meant the last one is the 500.
Okay.
Okay.
Your Honor, what did that place the total bond at?
I don't know. The clerk would have to add it up.
35, 36, 41, 41.5.
Your Honor, I would, if I may, Your Honor, my client here is 22 years old. I doubt he's seen $41,000 in his entire life. I would certainly ask if the court would
No,
reconsider that.
when you start carrying a gun and ammunition, that's not a trivial thing. So whether he's 23 or 53, if he's carrying a gun, he's a violent criminal. And violent criminals will face bail, and they'll face a long time in prison. But that's just the way it is. So many people are killed almost every day by stupid people carrying guns. It's just beyond the pale. And so the system, the whole system should just say no to guns, period. And if you carry a gun, you deserve to be locked up.
Thank you, Your Honor.
Okay, and next is Jessica Ree.
She bonded, Your Honor.
Oh, okay, thank you. Okay, and next is Nigel Renee.
He also bonded.
Okay, Reynolds, Alfonso Reynolds. Oh, you're Mr. Reynolds? I am. Okay, all right, Mr. Reynolds, you arrested felony for trafficking in meth. It's a $50,000 bail. Possession of cocaine is $1,000. Possession of drug paraphernalia is $500. That's all reasonable in itself, so I'm okay with all that. And then no firearms or ammunition, and no illegal drugs. Because of his drug history, he'll be drug tested once a month, random drug testing. Thank you. Okay, next is Retro Veto. Retro Veto. Okay, and Retro Veto, burglary of an occupied dwelling. Okay, I see Okay. Let's see, burglary of an occupied dwelling, the 5,000. When I look, he doesn't have much history. So we'll go ahead and leave the bonds as is, which is then criminal mischief is 500, petty theft is 250. And no possession of firearms or ammunition.
No return to the location, Your Honor?
Yes, thank you. No return to the location. Next, we have Robertson. Okay, Mr. Robertson, you're arrested for a felony aggravated battery causing great bodily harm. And the bail is $3,500. Your risk assessment is high. Okay, all right, we'll go ahead and change that to be $5,000. And no ammunition, no weapons, and no return, no victim contact.
Excuse me, Your Honor, what did you say the bond amount was?
5,000.
Okay.
5,000.
Thank you.
Okay, next is Roberts.
Mental health, Your Honor.
Okay. We'll go ahead and reset that.
Your Honor, if you appoint the public defender?
And I do appoint the public defender.
We'll waive his appearance, Your Honor.
Okay. Well, the ROR, and is that possession of a firearm by a convicted felon?
Yes.
Is that, did I read that right?
Yes, Your Honor.
And he's given ROR?
Probably, Your Honor, because the state did not file within the 33 days. I cannot confirm that right now, but that would be my assumption.
Well, have you ever filed? So is this, so I have an aggravated battery on a person 65 or more, and then paraphernalia. So this possession of a firearm by a convicted felon, was that ever charged?
Yes, Your Honor. Excuse me, arraignment is set for November 9th.
Oh, okay. So now that circumstance has changed and he needs a regular bail?
Yes, Your Honor.
Okay. All right, since it's a firearm involved, it's a $20,000 bail. And then the possession of cocaine, we'll just do it at $5,000. And then no firearms or ammunition, no return to the scene of the incident, no contact of victims or witnesses.
I apologize, Your Honor. Just for my clarification, are you doing those conditions on the out on bond, or are you doing those conditions for the new case?
Oh, no. I meant, I was talking strictly about the out on bond, because that's possession of a firearm by a convicted felon. That's what I was talking about.
Okay, so with regard to the new case?
Then the new case, what is prescribed on the schedule? Do you know for that aggravated battery on a 65 or older?
I don't know offhand, Your Honor, but if you give me a moment.
Yeah, I'm just.
It can start at 3,500, Your Honor.
Let me look at who he is. Looks like 13 felonies, 18 misdemeanors, 2 failures to appear. Risk assessment is moderate. So we'll go ahead and change the aggravated assault to be 5,000, and then possession of the paraphernalia, 500. And then we've already talked about the other. Yes. Yeah. Right. So it's 20,000 plus the cocaine was 500.
Is it 500 or 5,000?
What did I?
That's the part that I missed.
You said
Okay, I said,
5,000.
yeah, I'm like, I have
5,000.
5,000.
Count two is 5,000.
Yes.
Your Honor, with regard to the new law, are there any conditions with the aggravated battery, someone over
So it'd be,
65?
no contact, I'm sorry, I may have thought it and didn't say it. So no contact and no return, and then no firearms or ammunition. Was there anything else?
No, Your Honor.
Okay, good, thank you for reminding me. Next, we have Christian Rosa. Well, just once. Okay, Christian Rosa. Christian Rosa. And this is a failure to appear in court, and that judge set a no bail. And so you'll have to see him or her to get a bail. Next, we have David Smith. Mr. Smith.
Yes.
Mr. Smith, you're charged with a felony, tampering with a physical evidence and possession of cannabis. And looking at your assessment page, it's low to moderate. You don't have any felonies. You do have 3 misdemeanors. And so we'll leave it as is, tampering with physical evidence. The existing bail is $1,000, and then possession of cannabis, we'll leave it $100. And no firearms, no ammunition. State, was there no return? Oh, here's a second case. I didn't notice it. Here we are. And this alcohol beverage open container, we'll leave it at the $250 that it's already set. Okay, now we have Kelly Smith.
Refused, Your Honor.
Okay. And then the failures to appear, that judge can deal with it. And then it looks like we have both failures to appear. So there's 5 of them. Okay. Okay, Kelly Smith. No, I've already done that. And then we have Alice Temple. Yeah, he waived the appearance.
If the public defender was appointed, I would waive the appearance, yes.
So you weren't appointed.
Were we
Yeah.
appointed?
Yes.
And then you said to be set by the presiding judge.
Right.
Thank
Yeah. Okay, Then we have, are you Alice Temple? Am I saying Temple? Yes. All right, and, well, there is a felony here, so we can't plea it out. But, so, all right, there's just so much background, so, so anyway, so the possession of cocaine is set at 1,000, which is fine. And then the cannabis and the paraphernalia, each of them is 100. So no firearms or ammunition, and no return, no contact. And then we have Bryant Thomas. Okay, you're out on ROR. ROR for possession of cocaine and trespass on property after a warning. And,
Excuse me, Your Honor, there was no action taken on the trespass. So, according to the clerk of courts, it's the possession of cocaine and the possession of firearm by a convicted felon.
right, I didn't quite understand what you were saying. So we're going to revoke that, and
Disregard, never mind.
I apologize, but I have a hard time.
You can disregard, Your Honor, you can keep going.
Say again?
You can continue, you can disregard.
Okay, sorry. Okay, so the possession of, we're looking at, okay, so looking at the case that ends in 998, 1 AO. So the possession of cocaine, we'll go ahead and let me look at who he is. Well, okay, sir, Mr. Thomas, right?
Yes, sir.
Okay, Mr. Thomas, it looks like you have 14 felonies, 39 misdemeanors, 4 failures to appear, 25 unknown, and that's just the state of Florida.
Your Honor, what are these being brought up about? I was just, I was not caught in the car. I was being blamed for burglarizing the car, but I was just using the bathroom in the back of a vehicle against a wall. But I suspected me of doing something else, but someone.
Okay, I think you're talking about the attempted burglary of a conveyance or trespass on property after warning. I'm not quite sure what you're talking about, but all right, we'll go ahead and do the, set the, okay, we'll go ahead and do the possession of cocaine. We'll do that at $1,000. And then trespass on property after warning, we'll do that at $250. And on that case, which is the 19981, no return to the scene of the incident, and no contact, no firearms or ammunition. But when I glance at your background, you've never been involved in any of that. But still, don't do that. Okay, and then you have a new charge, which is attempted burglary of a conveyance. And they have it at $1,000, and we'll leave it as is.
Your Honor, there are 2 counts of that, so will it be 1,000 on both? It's
yeah.
from the same incident?
Yes. Yes is the answer.
Okay. And no return, Your Honor?
Yes. All right, that's all for him. Okay, and then this is Thomas. That's Thomas. Okay, now we're back to Throckmorton. Public Defender, did you need a couple minutes to talk to him?
Yes, Your Honor, and actually, if I could speak to the clerk for a moment as well.
Yes.
Yeah, no, it's,
What's the net?
could I ask pretrial services for a calculation of the credit time that has been served by Mr. Throckmorton?
One moment.
Thank you.
For the current case, 2 days.
2 days?
Yes, sir.
Is that the date?
Well, we may have to do this another day if there's going to be this much discussion. I don't want anyone to say that we rushed them, so we're going to have to do it another day. So let's, so let's go ahead and do what we have in front of us. So I have this ROR, which has burglary of a structure, number 2, possession of meth, number 3. So are we doing anything with these 6 counts?
Your Honor, that is his out on bond. Formal
Right.
charges have been filed. Pretrial is set for November 21st. So you have
Okay.
the option to revoke or you
I would
can
revoke
sit in your bond.
those, and, and the burglary of a structure, we'll do that at 5,000. The meth, we'll do it 2,500, so it's 5,000, 2,500. And then, what's ROWOV?
Resisting officer with violence.
Oh,
According to the
resisting
clerk
an
of court,
officer.
Your Honor, there are
Number
no
3.
action.
I only heard one O.
Number
Your Honor,
3.
there is no action taken on, according to the clerk of courts, for the resistant officer without violence, the false information to the LEO, and possession of drug paraphernalia, as well as the petty theft. There are no actions, so it's just count 1 and 2.
So just, okay, so we're just dealing with count 1 and 2. Okay, and then we, and so you have those bond amounts, the amounts. Okay, and then we have a new case, which is, it ends in 7286. Trespass on property after warning, it's $500. And so we'll leave that as is. And,
No return, Your Honor?
say again?
No return?
And yes, no return, no contact, no firearms or ammunition. Okay, thank you. Next case.
Please, Your Honor.
I'm sorry,
May I
did
address the court, please?
I forget something? All right.
I'm just at a loss right now because I'm confused as to the nature and the chronology of what we're talking about. Because
Okay, sir, we've already disposed of your case. Now let's go to Mr. Turner, Devontae Turner. And I think you wanted to talk to him, or?
Your Honor,
have
he is
talked to him?
interested in the plea, but as it would be a violation of probation plea form, I don't know if we have any of those plea forms here. I've asked if anybody has
I
a
believe we do.
I just looked.
They may be over there.
Yeah.
Take the plea when the next time we'll have a court date.
I don't know exactly off the top of my head, but
Oh. Probably. One is the 60 days, and then the other one would be adjudication and credit time served. No valid. Defense, is that correct, that you would then be resolving both cases?
At this time, we are not going to be accepting the plea.
Oh.
We asked the court to set bond in these cases.
Oh, okay, all right.
Well, Your Honor, that being the case, defendant is going to be held no bond. It's a failure to appear on both cases.
Okay, all right.
I got a paid attorney. I
That's it.
ain't take the plea because I wanted to talk to my paid attorney first.
Okay, that's fine, that's fine. No prejudice, that's great. And then, okay, that's it. Okay, State, I think we're done.
Yes, Your Honor.
Thank you, Your Honor.
Okay. Everybody, for a Friday afternoon, I'm glad we're done. And thank you for letting us push through.
Question?
Okay, next is,
Yeah, that's what he said.
next is Paul Brenson. Is this Paul Brenson?
Yes.
Okay, Mr. Brenson, you are, I don't understand why I have a state attorney information. Was this, what am I supposed to be doing something with it?
Is it on this case, Your Honor?
Yeah, let's see, this is tampering with a witness 2 times, tampering with a witness 2 times, and so it was filed October 21. Maybe this is, and then
Is it a reset? It is a reset.
then I, looking at this paperwork, tampering with a witness, I see that there's a bail bond.
He's out on bond.
He's out on bond.
Yes, and one of the cases is tampering with the witness 2 count.
Okay, all right, so out on bond, and it's an $8,000 bond, so that bond would be revoked. So that bond is gone, and we'll go ahead and change it to be $20,000 in that case.
Your Honor, I apologize. He has a new law offense, and then he is out on bond on 2 cases. Can you give case numbers, please?
Yes, case numbers, yes. So this would be, can I give you the last 4, or do you
No,
need
Your
the
Honor,
full?
if you could give me the full thing, please.
Full number, okay. All right, it's 2019 CF, I think that's a 0, 13098 AO.
And you're revoking that bond and setting it at 20,000.
Yes,
Okay?
all right,
Right,
and then we have
Your Honor, is that each count?
20, say, it only shows,
It's
It's 2
tampering with a
counts.
witness with 2 counts.
it is 2 counts?
Yes, Your Honor.
Okay, let me see here. They just have it written as like, well, maybe this is, no, that's different. All right, since I can't tell from the bond, initial appearance bond paperwork I have, so you're saying it's 2 counts, so we'll just do 10 and 10.
Okay.
Okay, then I have a 2019 CF 0066, I think that's a 50 AO, and it's, this is lewd and lascivious battery. I can't tell if there's more than 1 count. The bail amount is 15,000. So we'll revoke that. So is there more than 1 count in that case?
No, Your Honor, it appears just to be the 1 count.
All right, so we'll go ahead and change that 15 to be 30. So it'll just be doubled to 30. Then, okay, then I think we're down to the newest offense, which is aggravated assault with a weapon. And it was set at none. The arrest warrant was none. I think when I looked at this, was this where, okay, so we'll go ahead. What's your suggested bail amount for this aggravated assault with a weapon?
$5,000, Your Honor. Your Honor, this was a reset from yesterday because Mr. Brinson indicated that he had an attorney, or at least was going to get one. We haven't inquired yet, so I don't know if we're proceeding without his attorney being present.
Well, this is, you know, the regular time, and that's, you know, we're here. If the attorney's not here, they can always ask for a new bail hearing. So we'll go ahead and do, we'll go ahead and aggravated assault. We'll go ahead and do that at the $10,000 with $10,000 and then we'll do no illegal drugs, do not return to the scene of the alleged crime, do not contact the alleged victim, witnesses, or co-defendants, do not leave the state of Florida without court permission, do not possess a weapon, firearms, or ammunition. All right, State, are there any other conditions?
No, Your Honor.
All right, thank you very much. Next defendant, please.
Public defender, or is he still responsible to get his own private attorney?
Right, he has a private attorney as far as what we've been told. If Okay, this is Fallu. Are you Mr. Fallu?
Sir.
Okay. This is, you have been arrested just for a felony, aggravated assault with a deadly weapon, a violation of domestic injunction, carrying a concealed weapon, and open carry of a weapon. And the weapon, if I remember right, is this the one that's a knife?
Yes, Your Honor.
Okay. Whether it's a gun or a knife matters to me as far as my thinking. So even though both of them can kill you, I see he has arrests of aggravated assault, out-of-county warrants, battery. However, he has no Florida felonies, but does have misdemeanor, no failures to appear. All right, we'll go ahead and aggravated assault with a deadly weapon. We'll go ahead and make that as $10,000. Violation of domestic violence injunction, we'll make that at $2,500. Carrying a concealed weapon, which I believe when I read it, it's just carrying the knife.
Yes, Your Honor.
Okay, and so we'll go ahead and make that $1,000 since it's sort of a subsidiary of count one. Open carrying of a weapon, we'll do it $1,000. You are not to take any illegal drugs, do not return to the scene of the alleged crime. Now, do you live at or do you have things at that residence?
Your Honor, if I may, this event occurred out in a public place. That's the scene.
It did?
If I could speak to probable cause, he was in a public place when this event occurred. I would ask that possibly have that factor into lowering the $10,000 bond on the ag assault.
All right, do not return to the scene of the alleged crime. Do not contact the alleged victim, witnesses or co-defendants, your attorney will do that. Do not leave the state of Florida without court permission. Do not possess any weapons, firearm, or ammunition. And like I've already said, do not take any illegal drugs. Sir, do you understand that?
Yes, sir.
All right, thank you very much. Next is Tony Key.
Yes, sir.
All right, Mr. Key, you've been arrested for a felony battery on a person 65 years of age or older once, and then a simple battery, but with one prior, and then another simple battery with two priors. Looking at who you are, it says here you have, so yes, I want to make sure I have the right name, Tony Key. Tony Key, all right, you have 6 felonies.
What?
6 misdemeanors, 1 failure to appear. And they run grand theft, drug issues, drugs, battery. The battery on a person 65 years or older, we'll go ahead and do that at $2,500. Battery, which these other 2 batteries, are they misdemeanors?
No, Your Honor. Wait.
There are 2 cases.
The first one, the battery on a person,
Is a misdemeanor, Your Honor, yes.
is a felony, right?
With 1 prior?
Because this is indicated as a felon, so one of them is a felony.
Yes, Your Honor. The battery on the individual over 65 is a felony.
That's what I thought. Okay, and then the other 2 appear to be,
Well,
are they felony also because of,
battery 1 prior is a felony as well.
because of the priors?
Mhm.
Okay, all right.
Your Honor, if I may speak to probable cause on this one?
Oh, yes, sir.
Just for the record, my client is 64 years old. I believe the intention behind the statute at 65 or older is to protect the elderly from being battered by those who are under 65. My client is right at that level. Seems strange to charge someone who is 65 above with battery if someone is 65 or above, and I may ask that we somehow downfile this to a battery. Or at least let that factor into your bond assessment.
Well, I don't see that it goes to probable cause, it just goes to consideration. State, did I miss something?
No, Your Honor, you would be correct. It doesn't go to probable cause as defense indicated he is 64, which is under the 65, and his mother is over 65. So she is the target that is supposed to be protected.
So he has to, so the allegations are that he attacked some woman over in her 80s. He's got to be in her 80s, I assume. And so when I read this is an incident. So anyway, all right, sir, we'll go ahead and on the other 2, we'll go ahead and do 500 and 500. And so then, sir, you are not to consume any illegal drugs. You have no contact with the victim. Did you live with your mother?
Yes, sir. I was taking care of her.
Okay, well, when you read these allegations, that's not going to be anymore, at least in the long term, or short term, I mean. So you're to have no contact with her. You are allowed to go back one time with law enforcement to get your stuff. Now, stuff means clothing, any work tools, things of that sort. We're not moving furniture.
Yes, sir.
And so call law enforcement and then go there and get your stuff and go reside somewhere else Now, that doesn't necessarily mean forever, but it does mean for the short term. Do not contact her, and do not possess any firearms, weapons, or ammunition. Do not commit any kind of crime, such as driving without a license. Do not leave the state without getting permission. And state, did I miss anything?
If you could specifically order that they maintain a separate residence, please, Your Honor.
Right, okay, I'll say it that way also, but that's what I thought I said. You can't reside with her, so you have to have separate residences. And so get your stuff and live somewhere else while this case is pending. Okay, anything else from anybody? Thank you very much.
Your Honor, just stand, I apologize.
The clerk just said there's another case here. Okay, here's,
Your Honor, just for standard, are you appointing the Public Defender's Office on all of these cases?
yes. All of the defendants today who qualify for the Public Defender's Office, I do appoint. And then we have, and this is a second case for battery on a 65-year-old person, and then another battery. I don't know why, let's see. It is.
Your Honor, it seems the court case numbers are the exact same numbers. Are they?
No, they're two different cases.
Okay, can you distinguish, state, can you help me? Is there a different defendant, a different victim in here? I guess I didn't pick that up.
Not that I could detect, Your Honor.
I guess what I'm confused then, why do we have two arrest warrants, or arrest affidavits?
One is a warrant, Your Honor, and the other one was a probable cause.
Why?
Arrest.
Well,
Warrant?
okay, I'm not, okay, yes, I see what you mean. Here's a warrant. But I'm concerned that paperwork-wise, we're doing the same incident. When I look at the arrest affidavit,
Officer Keys, I apologize. From my paperwork, I can't tell which is which. Can you say which one is the warrant and which one is the piece?
The warrant is the 22 CF 1257 AO. That's the warrant.
And the PC affidavit is 22 CF 12599.
it says here, victim
Number yet in my system.
Axon via SYNC, sync? And the other one has the same name. Yeah, can we take a second and would you look to see what? Punching his mother in the face. The defendant exited the residence through the rear door, and then punching his mother in the face. The defendant exited through the rear door.
Your Honor, as there actually is a warrant, and I'm assuming it's been approved, I would ask that you do the bond on the warrant, which is the 22 CF 12575. And with regard to the PC affidavit, Unfortunately, Mr. Key is also being held on that only because of the charges. I don't want to ROR him, but if you could give him a nominal bond of $100, then it could be clarified at a later date.
All right, okay. All right, the warrant one, yeah, here's the warrant one. Let me just. Okay, so the affidavit one, which is the 599 case, let's go ahead and change that to be $100 for count one, and then $100 and $100, so it's $300. And then, and the reason for that, for the record, is I think it's just duplicate until the state looks at this, and so state, you know, can you please make a side note to look at this carefully after court this morning, and perhaps dismiss or I guess you haven't filed any charges, but we need to release him on that one if.
Yes, Your Honor. It will be clarified shortly.
Yeah, okay, and then on this other one, which is battery on a person 65 or more, we'll go ahead and change that to be $1,500 on count one and $100 on count two. And then the conditions are no contact with his mother or anyone else mentioned in the fact statement, and he is to live separate and apart. I've already talked about law enforcement helping him get his stuff, and no firearms, ammunition, and I think I've read everything else. So have we covered everything for this gentleman?
Yes, Your Honor.
Okay. All right, folks, thank you very much. Okay, now, we should have Vanessa Joseph. All right, Ms. Joseph, let me look at the paperwork for a moment. And this is a misdemeanor battery, but looking at Vanessa Joseph, okay.
Your Honor, she qualifies for pretrial release. I have no objection.
Okay. All right, pretrial release. Yes, that's what I was just noticing. You may be released on pretrial release. Do I need to add any conditions to that?
Yes, Your Honor, you do.
Okay. All right. In addition to what is in the pretrial release document, you are to have no contact with the victim, and you are not to live with them, obviously from what I just said. So no contact means you can't live with them. Do you all live together? Do they live together?
Your Honor, if I may, Ms. Joseph is pregnant, and the alleged victim is the father of the child. If you would at all consider no hostile contact, I know that my client has expressed that wish.
Well, I can't do that because I could do it if he was here and said that he agreed, but, and I did remember reading that she's pregnant, but, so at this point, ma'am, you're going to have to live with some girlfriend or parent or somebody, relative, I meant to say, to have no contact with him, and so public defender, he can always come to the state and explain that he wants to change that. And, you know, we would do it. So at the temporary time, at the moment, we want to do things that are the safest thing to do. So if you're released, you must live somewhere else. If he wants to contact the state attorney, that's his right to do. You are to have no firearms, ammunition, do not commit any crimes, do not leave the state, and no contact means no contact. Don't email them, don't call them. State, anything else?
No, Your Honor.
All right, thank you very much, folks.
Thank you, Your Honor.
Next case. Next, we have Ian Lynch. Mr. Lynch, for the record, there is nobody present. Does not qualify for pretrial release.
His prints didn't clear, Your Honor, but they have cleared now, so he possibly can qualify for pretrial. If you wanted to do the bond or pretrial, that's up to you.
All right, so he does qualify for pretrial release?
No, Your Honor, he may qualify, and so what is the suggestion is you can order pretrial release if he qualifies, and if not, then set a $500 bond.
Okay. All right, when I look at, for the record, he has no felonies, no misdemeanors, no failure to appear, no criminal activity. And so the risk is very low. So we'll go ahead and do that pretrial release, which means on your own signature if you qualify. So answer their questions and give them the info they need to see if you meet the criteria to release you. If for some reason you don't, then your bail is $500. And then no contact. And so no contact means no contact. You can have your lawyer contact them or take their deposition, whatever, but no contact at the present time. No possession of weapons, firearm, ammunition. Do not commit any type of crime, which includes driving without a license. Do not leave the state. Do you understand everything? You understand everything?
Yes, sir.
Okay. Next defendant, please.
Thank you, Your Honor.
Okay, next, Kareem, how do you say your last name?
Your Honor.
Okay. Sir, this is a misdemeanor, domestic violence. There's nobody here to give us any information from that side of the case. This is a misdemeanor, so we'll go ahead and do a $500 bond.
He qualifies for pretrial, Your Honor.
Okay, he does. All right, so we'll do pretrial release. And so with pretrial release, sir, you are to have no contact with the victim. Do you and she live together? Okay. You can go there one time with law enforcement to secure your belongings. By that I mean your clothing, any tools that you need for work. And so this isn't forever. This is to get things down the road and calm down, and then the attorneys can always change it, agree to change it. So to no contact other than getting your stuff. You're to live separate and apart. You are to have no firearms or ammunition or weapons, do not commit any crime, do not leave the state. State, anything else?
No, Your Honor.
Okay, sir, you understand everything? All right, thank you. Next case. Okay, next we have a misdemeanor, domestic violence, and criminal mischief. We have nobody present to speak to this. And when I look, it looks here, felonies 4, misdemeanor 7, failure to appear 0. And Florida adult conviction, including burglary, petty theft, criminal mischief, cannabis, burglary of an unoccupied structure. All right, we'll go ahead and do.
Qualifies for pretrial, Your Honor.
He does?
Mm-hmm.
Okay. We'll go ahead and allow him to be released on pretrial release. This is domestic violence, so, sir, you are to have no contact with the victim, witnesses, or defendant. You are not to have any firearms or ammunition or weapons of any type. Do not commit any crime. Do not leave the state. And you are to live separate and apart from the victim. So, state, is there anything else?
No, Your Honor.
All right. Sir, do you understand that?
Yes, sir.
All right. Thank you very much. Next case. Okay, are you Jimenez Robles? You Mr. Robles?
Yeah.
Okay.
Yes.
All right, and so this is, sir, this is a misdemeanor battery, and looking at who you are, says here, no felonies. Did pretrial release, it says, does not qualify, but risk assessment is low. Is there?
He has an open Seminole County case,
Oh,
so he doesn't qualify for our admin order.
All right, and so.
Your Honor?
Yes, sir, ma'am.
With regard to the open Seminole case, it is a domestic violence battery against the same victim 2 days ago. So he was released from jail and then went and attacked the same victim.
All right, anything from the defense?
Your Honor, we would just point out the fact that his risk assessment is low, and we would ask that you set a bond in this case.
All right, sir, your bond is $10,000, and you are to have no contact. You are to live separate and with the victim or witnesses. You are to live separate and apart. You are to have no weapons, firearms, or ammunition. Do not commit any crime, which includes violating a domestic violence injunction. Do not leave the state without getting permission. Do you understand that?
Yes, I do.
All right. State, is there anything else?
No, Your Honor.
All right, thank you very much. Next case. Okay, and let's see, Connaughton Sadler? Okay, Mr. Sadler, you were arrested for a misdemeanor, dating violence battery.
And he qualifies for pretrial, Your Honor.
State has no objection.
I'm sorry, I couldn't hear you.
He qualifies for pretrial.
Oh, no objection?
Right.
Okay, without objection from the state, we'll go ahead and allow him to be on pretrial release. You are to have no contact with the victim. No contact means no contact, no phone calls, no emails. If you live together, you can go back one time with the sheriff to get your personal items. You are to not possess any weapons, firearm, or ammunition, not to use any illegal drugs, to not commit any crime, which includes violating injunctions or driving without a license, do not leave the state. Sir, do you understand everything?
Yes, I do, but I'm supposed to go back to Chicago this weekend to stay.
Okay, so what's your status of being here?
Say that again.
Are you here as a tourist or?
I was staying here, but I'm originally from Chicago, but I was gonna go back for a little while to get things right.
Well, I don't know, pretrial release, that sort of does not affect it.
Not if he qualifies. He still can be released pretrial.
Well, you know, let me just, I'll go ahead and allow you to be on pretrial release and to reside in the state of Illinois, because you might not technically be in Chicago, but if you can reside in Illinois. But if we lose track of you, if you disappear, there'll be a warrant issued and they will catch up with you eventually and bring you back here. Do you understand that?
My kids out here. I'm not going anywhere.
All right. Whatever this incident is, don't let it get bigger. Okay? All right. Was there anything else I needed to say or do? Okay. Thank you very much.
Thank you, Your Honor.
Okay, and next we have, it looks like an out-of-county warrant. So are you Mr. Evans? Okay, Mr. Evans, there's original warrant is from Lake County, and so there's a no bond situation. So we will notify Lake County. They have a certain period of time to pick you up. Otherwise, you'll be released in Orange. And if you are released, you need to go to Lake County and get this straightened out so that every time you come in contact with law enforcement, they're going to be arresting you for an outstanding warrant. So you need to take care of that warrant, whether you're transported there or whether or not and you're released. That's going to bite you. You understand that? Okay. All right, I don't know anything about it, but you need to go there and figure it out so you don't keep getting arrested. All right, thank you very much. Okay, and next is Jerome, is it Hawk?
He refused, Your Honor.
Okay, we'll go ahead. This is a out-of-county warrant, and so we'll notify Seminole County that we have him in our custody. Thank you. Next we have Department of Corrections, and this is a violation of probation. So, I did VOPs for a year, And so you need to look at that violation of condition 12. The others, so you're going to go to VOP court, and you're going to need to explain why condition 12 was violated, if it was violated, why, and how can we get you back on track. There's really no big desire to send you to prison or to put you in jail for many months. That's not really the purpose of VOP court. VOP court is to try to get people back on track when they seem to be maybe slipping. So go get this thing worked out, and then whatever the resolution is. I know I always tried not to send people to prison for especially technical violations. But okay, thank you very much, sir.
Thank you, Your Honor.
Oh, I'm sorry. Court reporter, the last name is H-A-U-K-E.
The last defendant who was standing here was Mr. Manahan. Houck refused.
Was this? Okay, I got paperwork mixed up here. Okay, so that gentleman was?
This gentleman that was just standing here was Alexander Manahan.
Manahan, okay, that's right. All right, here, give you that. Okay, now we got the paperwork right, sorry. And here's Manahan, and that's it. All right, we will adjourn for 1 hour. It's right.
33 motion? We good?
We have 33 days? Okay, we have to do 33 days. Now, I'll go ahead and just do the last 4, which is Azula, is the 1194.
Denied, information was filed.
Oh, I have to, the one? Okay, all right. The court reporters is 22CF011194 Apple Orange R. With an R? Is R on the end? That's not usual. Yeah, that's, the clerk says that's, the R is a typo. Okay, and then, say again. And then Azula is the last name.
And it was denied, Your Honor.
Okay, next we have State of Florida versus Egner, E-G-N-E-R, and the case number is 22CF011251 Apple Orange.
Granted, notice of non-filing.
Okay, next, Diaz, D-I-A-Z, and the case number is 22CF010821 Apple Orange. And I notice all these have that.
Granted, notice of non-filing.
No, but it is every one of them, so, yeah, that would make sense, but, yeah, I'll just cross through it. I'm sorry, I missed the state.
It's granted. Notice of
Granted.
non-filing was filed.
Okay, next is Diaz, 22 CF 009143 Apple Orange.
Your Honor, with regard to this case, it's inappropriately filed. He was arrested for one case and then released and then rearrested 4 days later. And so because of that, the bond on the first case was revoked. This is the first case. And I have provided case law to defense that indicates once that happens, he is not entitled to the 33-day motion, Your Honor. So I would ask that this be denied.
Your Honor, we just received this case law this morning. I've had a chance to briefly look over it, haven't had a chance to do anything deeper in the dive. I would still ask that you extend the, or allow him to be 33rd dayed, but if the case law holds up, then it does seem that the state's made a valid argument.
Okay, thank you. Next is Patrick, 22 CF 011204 Apple Orange.
Granted, notice of non-filing.
And then Santiago, 22 CF 010918 Apple Orange.
Granted, notice of non-filing.
Okay, Newton, 22 CF 011215 Apple Orange.
Granted, notice of non-filing.
Okay, Bryant, B-R-Y-A-N-T, and it's 22 CF 010404 Apple Orange.
Granted, notice of non-filing.
Okay, Boyd, 22 CF 011239 Apple Orange.
Granted, notice of non-filing.
Velez, V-E-L-E-Z, 22 CF 010179 Apple Orange.
Granted, notice of non-filing. Your Honor, just to clarify, on Velez, is the last number a 0 or a 9?
Are we talking about Soar Angel Velez?
Yes, Your Honor.
Okay, and the last number is a 6. Hold it. I think I know what you're talking about. Here is, when I looked at the next one, it's the same name. So it says, I think you're looking at the 22 CF 010170 Apple Orange.
Okay, and that is granted notice of non-filing.
So we have both of his cases.
Your Honor, he has 4 other cases, 171, 177, 175, and 176. All of them should be granted.
Okay, good. Okay. Speaking for the record, is Velez again, 22 CF 010177 Apple Orange, granted. Another Velez, this one is 22 CF 010171 Apple Orange.
Granted, Your Honor.
Velez again, 22 CF 010175 Apple Orange.
Granted.
Now, Robert Harris, 22 CF 011268 Apple Orange.
Granted, notice of non-filing.
Robinson, 22 CF 011144 Apple Orange.
Granted, notice of non-filing.
That's the last one.
Yes, Your Honor. So for the record, the Marlon Manuel Diaz, 22 CF 9143, were you granting that, denying it, or giving defense more time, Your Honor?
Okay.
If I may, Your Honor.
Marlon Diaz?
Yes. It's the 9143.
Let's see.
The case law that has been provided to defense counsel is an unpublished opinion. I would have a difficult time making a decision on the record right now based on an unpublished opinion.
Okay, so it's denied at the present time?
Yes, Your Honor.
Okay, right, that's how I did it.
Thank you.
Okay, Madam Clerk, other than things I need to sign, are we good for an hour? Okay, we're going to take a break for an hour. The clerk tells me everybody's in agreement. That's not causing anybody any problems. Corrections is good. Everybody's good?
Yes, Your Honor.
All right, see you. Right now, for the record, is 10:10. So we'll see everybody at 11:10.